Imagine someone's 27 years old. They have $20,000 in the bank, no real estate, but they have substantial debt, owe back taxes, have no spouse, no kids, and the debts are in excess of $20,000. Does this individual need to do any estate planning? Well, that's a trick question because obviously, yes, they need to have their healthcare directive and durable power of attorney in place. But that aside, incapacity planning aside, let's look at testamentary planning, planning for after your death. Does this individual need to have a will or revocable living trust in place? Well, let's look at what they do. A will is a stack of papers that says who gets your stuff after you die. A revocable living trust is an even bigger stack of papers that says who gets your stuff after you die, except it's on steroids. Now, if you don't have any planning, your assets will transfer in accordance with the intestacy statutes. If you live in Minnesota, you reside here, it'll be the Minnesota intestacy statutes. If you reside in another state, it'll be that state's intestacy statutes. But if you don't have anything, we really don't care, right? Because if your debts outweigh your assets, then it doesn't matter that you don't like how the intestacy statutes give your assets out. It's fine. But imagine this person, this 27-year-old that has more debt than assets, is Jimi Hendrix. Now the story changes. My name's Gregory Singleton. I'm an estate planning attorney with Signature Law, and we're here to talk estate planning. As part of our Celebrity Estate series, we're going to look at today at the estate of Jimi Hendrix. So let's just hop right to it. Very little intro is probably necessary. This is Jimi. Just in case, he was a legend of rock and roll. And if you don't know him still, just look him up. You might be impressed. He died by asphyxiation on his own vomit. That was in September 18th, 1970. He was age 27. Now, there are some conspiracy theories that he was murdered. That's neither here nor there. That's for a podcast somewhere. But what we're here to look at is his estate. Everything that I said in the introduction earlier was true. Very little wealth, lots of debt, no family or of his choice, no spouse, no kids, but his potential for assets obviously was huge. Jimi Hendrix died without a will. That means you die intestate. If you die with a will, you die testate. He was a New York resident, so New York law is going to apply to his probate. Under New York law, it's pretty similar to Minnesota law. Essentially, spouse gets things, and kids get things, and parents get things, depending on who survives you when you die. Now, with no spouse or kids, everything went to Jimi Hendrix's father. Now, his relationship with his father, Jimi's relationship with his father, was strained to be kind and mostly estranged according to others. Now, the assumption was that if Jimi Hendrix had put together a will, he would have left everything to his brother Leon, his best friend. Now, the reality is that Jimi Hendrix didn't have anything, didn't have any will or trust. He had no plan, and that is a bad plan. Because of that, Leon, in accordance with the law, got nothing, and his father, who he's been estranged from and had no real relationship with, got everything. And everything included, in this case, the rights to the intellectual property, including Purple Haze, which was released shortly after his death. Now, after Jimi Hendrix died, his estate entered into over 30 years of litigation. It started with a contest of the probate and contested that the New York intestacy statute shouldn't be followed. And that's a loser argument right there. But when Jimi Hendrix's father died, the father's estate went to his adopted daughter from a second marriage. Now, maybe Jimi met this individual possibly 4 times in his life for 10 minutes apiece at each time. Leon was essentially cut out of his father's will. All he received was a gold record, didn't get any of the assets, which, by the way, when Jimi Hendrix's father died in 2004, the estate was worth approximately $80 million. Now, there was a lot of litigation that continued around these two estates. I'm not going to break them down. My focus is more on estate planning as opposed to litigation. My goal is to keep you out of court as opposed to look at what happens while in court. And quite frankly, a lot of it's not that really interesting stuff that's going on with the estate. There's other litigation about intellectual property rights that's a little bit more interesting, but that's beyond the scope of what my wheelhouse is. The takeaway, however, is that no planning means the court controls everything. When the court controls everything, they're just going to follow the law. Doesn't matter that you're totally estranged from your father. It doesn't matter that you have, let's say you have a situation where you have no spouse. You have two kids. One of them, the apple of your eye. The other one did the worst thing in the world and went to law school. And you would normally, had you done planning, disinherited the kid that went to law school, but you died without planning. That kid that went to law school is going to get half of your estate. Or let's say you had a partner of 30 years. You never got married. You just lived together and you kept your assets separate just for tax reasons, but you lived together and everyone thought you were married. And when you die, 150 people go into court and all testify, yes, we thought they were married. They should be treated as married, but there's no common law marriage in Minnesota. And the courts look at it and say, I'm sorry, you may be life partners, you may have lived together for so long, but the surviving partner gets nothing because you didn't do a will. These laws for intestacy are absolute. Now, earlier when we were looking at the estate of Jimi Hendrix, before I did the big reveal that it's Jimi Hendrix, which you knew from the title of the video, but if you've got no assets and your debt outweighs your assets, you probably don't need to do estate planning unless there is potential for assets in the future. Remember, our estate plan is not just covering today. We're going to have that will or trust that we've drafted until we either destroy it or draft a new one. And I've revised estate plans of people that are 30, 40 years old, written with carbon paper. So if there's any potential in your life for having a new baby, getting married, getting divorced, if you're in a long-term relationship, if you're going to be leaving home for the first time, if you might be starting a new business in the future, if you might be buying a new house, what if there's a chance that you could get a significant inheritance from a grandparent or your parent? What if you're really working towards accomplishing a significant accomplishment, such as writing the next Purple Haze, or maybe inventing something, or establishing a patent? These are all reasons to make sure that your testamentary document, either your will or your revocable living trust, is in place so that if you pass early, at the age of 27 or 37 or 47, and there is something to leave behind that you didn't anticipate, it goes where you want it to go. So that's my take on the estate of Jimi Hendrix. The lesson: failing to plan is planning to fail. Very simply. I didn't make that up. I wish I did. I hope you liked today's video. If you did like today's video, please hit the like and subscribe button. It really helps support the channel. We do new videos every other Wednesday. If you have questions, leave them in the comments below or send me an email. I tend to respond to email a little bit faster than the comments. Otherwise, until next time, this is Gregory Singleton from Signature Law.